Welcome to an episode of Behind the Scenes, a weekly program unveiling the biggest political developments in Somali politics. I'm Sultan Mohammed, your host and co-producer here on Wararka Media alongside Suleiman Hashi. On this week's program, as the mandate of the European Union-led naval force in the Somali Republic draws to a close, Behind the Scenes investigates and assesses the European Union-Somali Naval Agreement of 2008, which has directly trampled on Somali sovereignty and the supremacy of the Somali legal system. Now, what does this agreement actually entail, and what are some of the articles that directly insult Somalia's sovereignty? This is the topic on the program this evening. We hope you find this program very informative. Please like, share, and for similar content, do subscribe to Wararka Media's YouTube channel. You can also subscribe to Wararka Media Group's second YouTube channel, known as Wararka TV. You can also find programs you might like to watch, such as Mhahisale and Dulmar. And please also do follow myself, Sultan Mohammed, Suleiman Hashi, Engineer Yasin, and the wider Wararka Media team on our social media platforms, which should appear on the screen any moment now. Let's get straight into it. It was under Resolution 2608 of the UN Security Council that the International Naval Force mission known as Operation Atalanta in Somalia was extended in December 2021 for another 3 months until the end of March 2022. Now, the UN Security Council annually renews the mandate of this operation. The first question that needs to be addressed before we delve into the actual agreement, however, is what exactly is Operation Atalanta and what does it actually mean? Operation Atalanta, formerly known as the European Union Naval Force, or EUNAVFOR, was formally established under the UN Security Council Resolution 1814 on the 8th of December 2008. This piece of international law was further incorporated into Somali national law via the Somali European Union Naval Agreement that was signed by the Somali Transitional Government and the EU, represented by the French ambassador to Kenya, which essentially set out the legal scope and parameters of the EU and the wider international mission within Somalia and the Somali legal system. Now let's rewind back to 2008. The then transitional federal government of Somalia wrote to the president of the UN Security Council asking for international help to fight piracy and armed robbery against ships off the coast of Somalia. Indeed, in 2008, there were a total of 111 pirate attacks, which included 42 successful hijackings. However, in comparison to the estimated 30,000 merchant vessels which passed through the area, it is merely a fraction. Now, would there be a necessity to have such a large-scale international force against such a very, very minute problem that existed at that time? Now, that's for historians and academics to decide. However, there is, and it is clearly a simple small fraction at its peak of 2008, roughly speaking. Nevertheless, as a result of this request, the UN Security Council unanimously passed Resolution 1816, which authorized nations that do have an agreement from the traditional Somali federal government to enter Somali territorial waters to deal with pirates. We also have to remember that Resolution 186 also provided the legal pretext for the UN to begin establishing its mission in Somalia. The resolution called for the UN to provide economic, political, and technical support to Somalia. This skeleton mission would eventually evolve into the UN Assistant Mission in Somalia, or EUNSOM, under Resolution 2102, which formally established EUNSOM on the 3rd of June 2013, but this topic is for another episode. Back to the EU Naval Force mission in Somalia. Now, the naval force is composed of 26 members of the European Union and another 6 EU allied states, including Norway, New Zealand, and Colombia. Now, as stipulated by the UN Security Council Resolution 1816, the UN only permitted nations that, and I quote, have an agreement with the Somali government to enter Somali territorial waters to deal with these pirates. Now, what exactly is the agreement signed between Somalia and the EU that have given the EU and its allies the legal mandate to be within Somalia's waters? The agreement sets out the status of the European Union-led naval force in Somalia and the framework of the EU military cooperation. As we inspected the agreement, there are a number of articles that we have raised eyebrows for and sparked our interest to share with you. Now, have you heard, and I'm pretty sure a lot of you have, of young Somali prisoners detained in various countries across the world, such as India? Now, if you have, look no further. Article 7 of this very particular agreement that we're going to assess discusses what we call criminal jurisdiction and states the following, and I quote, "The competent authorities of a sending state or naval force shall have the right to exercise on the territory of Somalia all the criminal jurisdictions and disciplinary powers conferred upon them by the law of the sending states." So in other words, nations that are members of the EU-led naval force can implement their own domestic laws and punishments as they see fit upon Somali citizens that they accuse of piracy, rather than detaining and prosecuting or finding not guilty Somali citizens based on Somali law, which they are applicable for. Which is applicable to the situation. And this would ultimately mean two things from my own perspective. One, domestic laws of individual naval sending states, for example Norway, have jurisdiction within Somalia all of a sudden. And the naval team composing of over 30 countries would mean over 30 countries have some form of legal jurisdiction to implement their own laws within Somali territory. And number two, by implementing foreign law within Somali territory, it would imply that Somali law is not sovereign over all these other laws and would mean that it is somewhat inferior to these other laws, to say the least. Now, Article 13 is another extract from the agreement that has outraged many Somali legal experts. Now, Subsection 1 states the following: EU and EU nation personnel shall not be liable for any damage to or loss of civilian or government property which are related to operational necessities or caused by activities in connection with civil disturbances or protection of the EU-led naval force. Now, subsection 2 goes on to state that any damages that are not caused by the EU-led naval force due to, and I quote, operational necessities must be settled by, and I quote, diplomatic means. If we just try and imagine the manifestation of this article, we see a very dark and gloomy reality. Under this section, in a situation whereby an EU-led naval force states, so for example Norway or Colombia, kills a Somali citizen or damages either private property or government property, neither the personnel nor the country itself is legally liable for this action. In fact, it goes on to say that any dispute must be settled by diplomatic means. So this is further underpinned by Article 6 of the agreement, which further stipulates these following points. 1. All EU-led naval force personnel shall not be liable, and I quote, to any form of detention or arrest. Point 2. Papers, correspondence, and property of European Union-led naval force personnel shall enjoy inviolability. And point 3. EU-led naval force personnel shall enjoy immunity from all criminal, civil, administrative jurisdictions of Somalia under all circumstances. This means that if a navy was, or rogue elements of a particular navy were, to engage in illegal activities that hinder Somalia's economy, environment, or people, such as exporting charcoal, or protecting illegal fishermen, or even illegally extraditing and prosecuting Somali citizens without a fair trial, there would be no accountability for those actions. In fact, paragraph 3 of Article 6 clearly stipulates that all European Union-led naval force personnel enjoy, and I quote, immunity from all, and I say all, circumstances of criminal, civil, and administrative jurisdictions. So in other words, Navy personnel from 30 countries have the right to do as they wish in Somalia's territory, including detaining and extraditing Somali citizens at free will, ladies and gentlemen, at free will, without any form of accountability. Now, if we return back to Article 13, the initial article we were discussing, paragraph 3 states the following. in the event of any legal action instituted in connection with damages caused by foreign naval forces to any third party, so foreign, I'm referring to the EU-led naval mission to any third party, Somalia will not only stand in lieu or stand in its place, but it will also be liable for any compensation on behalf of the European Union-led naval force to the third party. And just to add insult to injury, the paragraph goes on to state that any compensation attributable to the European Union-led naval force can be paid partially, meaning that the EU and states that are allied to it within this naval mission are not even legally and financially wholly liable for any financial costs that there are. In fact, in other words, any damages caused by any of the 30 plus countries that are involved in this mission to a third party, Somalia is completely liable for this. Absolutely preposterous and an insult, not just to Somali sovereignty, but the Somali people and state as a whole. For Somalia not only to be liable for damages done by foreign naval forces, irrespective of how they are done so, but also the simple fact that none of the personnel are even liable for any damage caused to any form of Somali business, government, or killing any civilian. There are more damaging articles in this agreement that completely disregard Somalia's sovereignty. For example, Article 5 states, official correspondence of the European Union-led naval force shall be inviolable. In other words, Somalia is not informed of any developments or intelligence regarding the international naval fleet. Somalia is in fact kept in the dark, not just on the number of soldiers present, but the type of weaponry, deployment, the movement of soldiers, and the operation that they conduct. Somalia is unaware of what is going on in its coast. And consequently, naval forces are free to bring any form of weaponry and artillery they see fit, for example, nuclear submarines or heavy warships. And with Somalia being on such a strategical location, such movements can be utilized in such a detrimental way and a dangerous way, to be frank. Now, this point stipulated by this article, being Article 5, is strengthened by Article 4, which conveys that any naval force may carry out within Somalia's waters and airspace any exercises, and I want people to listen closely to the wording, because the wording in any legal text is crucial when interpreting it. And here we see the words any meaning anything. Anything is feasible. So any exercises with any weapons without even the basic requirements of showing flags in territorial sea of Somalia. So for instance, if one of the member states that has nuclear weapons, such as France, for example, deploys a nuclear submarine into Somalia, not only can it do so despite the need not to do so, we don't need nuclear weapons to defend Somalia's coast, but on top of this, they don't have to demonstrate the French flag when they are on the Somali coast to inform Somalia officials of their presence. Now, last but not least, and I want to point this out to you because this agreement is pretty big, and I'm pointing out the most important parts to the viewers. The naval forces are also immune to two more legal principles that have outraged many, including myself. Now, if you go back to Article 4, all personnel are exempt from passport or visa regulations, immigration inspections, custom controls on entering, leaving, or even within Somalia's territory. And this would mean that the personnel are basically above the law. Foreign personnel are above the very law they are here to protect, Somali law. The article allows any personnel to freely enter and leave Somalia at his or her will, and even the president himself would not be able to stop him or her from doing so. This enables smuggling of any form of weapons and drugs, and it would simplify the whole process because there's no such thing as checks. How does the government know what these personnel are bringing in? Whether this could be smuggling in weapons, right? So this creates the perfect environment for corruption, for blackmailing, for bribery, because this means that there can be no accountability. This means that the Somali law doesn't have the scope or the capacity, because of this inhibiting agreements, this disabling agreement, to kind of detain, search, and check what's coming into its borders and what's leaving its borders. Now, the second point I want to point out to you guys is all naval forces are allowed to freely use any means of transportation that they wish within Somalia, and this includes any, and I mean any, public roads, any airports, any ports, without any payment of duties, fees, tolls, taxes, or any similar charge. In fact, Article 5 goes on to say that the naval personnel are, and I quote, exempt from any form of taxation inside Somalia on their salaries, as well as any income received from outside Somalia. Also, Article 12 allows full enjoyment of the right to unrestricted communications by radio. It goes further, stating that Somalia must grant access to the frequency spectrum for all 30 plus nations free of charge. Ladies and gentlemen, free of charge. These are some of the points pointed out in this agreement. Not only are they allowed to use our ports and our airports for free, they're also allowed to use our communications for free. Now, when we amalgamate all these various factors, one thing is formed: the unlimited free access of foreign soldiers into Somalia, including her ports, her airports, free of any form of taxation, and contributing to return something back to these facilities and communities, doesn't exist. Surely, if you're using the ports, the airports, one should pay some kind of duty, some kind of tax, some kind of toll to kind of bring back to the communities within the area. But this doesn't exist, and this is what makes this agreement most preposterous. The fact that all personnel working, living in Somalia under this mission are not even part of the scope of the Somali legal system, including the simple taxation of income, is an insult to the Somalia's government. The agreement was signed in 2008, but what is interesting, I think, for you guys to know, is that there was no president of Somalia during this time. Let me be more clear. Of course, there was a president in 2008, but we have to look at the dates. Now, the agreement was signed on the 31st of December 2008, the final day of that year, whereas Somali president at the time, Abdullah Yusuf, resigned on the 29th of December. In fact, Somalia did not have a president until the election of Sharif Sheikh Ahmed on the 31st of January 2009. So this would mean that Somalia, the government of Somalia, signed an agreement of this large scale, of this large influence and consequence, without a president. Shocking. Now, while Somalia did technically have an acting president, such an official is of a caretaker nature, rather than signing international agreements that literally desecrated Somalia's sovereignty, law, and people. In fact, this is not the only mission on the Somali coast. In fact, Combined Task Force 150 is also another naval force, this time led by the US rather than the EU, that is present in Somali waters under the same UN resolution. Now, the current Somali government, represented by the Somali Permanent Mission to the UN, vigorously objected to any year-long renewal of the mission, a routine procedure in the Council. In a statement read to the UN Security Council, Somali Ambassador Abubakar Isman stated that Somalia believed the Security Council resolution on piracy and armed robbery of the coast of Somalia have successfully achieved their intended goals. Indeed, there has not been a single case of piracy hijacking in Somali waters since March 2017. That is a period of 4 years in which there has been no threat. While the UN Security Council unanimously voted to extend the mandate by 3 months to allow the transition of power, the EU and many member states have been pushing and striving to continue the arrangement to at least December 2022, against the wishes of the Somali government and despite the fact that there have been no pirate attacks in 4 years. What is clear is that Somalia is constantly under attack from all sides, but it isn't these foreign countries that we ought to blame. They merely see an opportunity in a people and a nation divided by greed and clan allegiance. It is Somalis to blame for giving away their country and resources. It is Somalis to blame. It is the previous generation that has failed our generation today. Not only have they failed to secure Somalia for the young, they have failed to rebuild Somalia. Instead, they have stolen, instead they have robbed, and instead they have deceived. And it's now 2022, literally almost 14 years since this agreement was signed, and we, the new generation of Somalis, are here to pick up the pieces that have been left behind. The Somali government must take immediate action now to protect Somalia's sovereignty and Somalia's unity.